Thank you. Ms. Johnson.
So, yes, I addressed you in closed on certain matters relating to Helen Steele, which I don't propose to repeat.
No.
But as part of that, I made an application for you to consider in her case extending the deadline for privacy redactions from the 11th of April. I'm instructed to make the same application on behalf of the call participant known as Donna for the same reasons. I don't think there is anything I can helpfully add in a closed session, so I don't propose to go into one. But I formally make that application for those reasons. The final matter upon which I wish to address you in open was on the potential for more than one statement in respect of Helen Steele and more than one deadline in respect of those statements. I've been able to take detailed instructions and discuss the matter in some depth with Miss Steele over the short adjournment. The risk of such a course is that as the inquiry knows and as Miss Steele has been quite candid about, short deadlines in her case can be counterproductive, presenting a stressor that prevents her from effectively engaging. Her proposal, if I can put it as such, but I certainly don't want to be appearing to barter, but a suggestion that might assist is for one deadline, and the deadline she seeks is the 6th of June for all of her statements, but with this important and sincere assurance that as soon as the first statement is complete, it will be served. And Ms. Steele wishes me to emphasise on her behalf that there is, of course, also a benefit to her of getting statements, as it were, off her plate and out of her mind, so she no longer has to think about it. But because there is so much cross-pollination of material, it feels like it would be counterproductive to work on one and then another and then another. And because of the reason that I've given regarding the counterproductivity in her particular case of the imposition of shorter deadlines. So in short, so what I ask is one deadline for Miss Steele of the 6th of June, with the assurance that as soon as anything is ready, it can be served, it's hoped, much sooner than that.
The deadline that you propose is both for privacy applications and witness statements. Is that right?
So yes, so that both matters can be worked on simultaneously, preventing the duplicative reading of documents.
Then may I explain the position of the inquiry, because I'm afraid that is not a workable proposal. She has already had the documents in relation to her relationship with Dines during his deployment, and privacy redactions have already been applied to those documents by the inquiry. There is no need to repeat the exercise. She does not have anything to do about that. The privacy applications that the inquiry seeks and must have promptly is over the Operation Muscat documents, those which relate to her attempt to find Dines after the relationship and his deployment ended. And I'm afraid to say that from the point of view of the inquiry, it is far more important that she makes her privacy applications in relation to the Operation Muscat documents, if she wishes to, rather than leave it to the inquiry, by the 11th of April. So this is an option which you may need to talk to her about before we wrap things up for good today. But that is a deadline which, for reasons of running the inquiry, simply cannot be shifted. As far as the suggestion about witness statements go, I will need to go back and speak to my team about the dates that you have proposed, but it would, I suspect, be easier for her, and it would certainly assist the inquiry more if we were to have her witness statement about her relationship with Dines separately, if she wants to do it separately from the witness statement relating to Operation Muscat. What I think, however, you need to speak to her about, and I need to speak to my team about, are uh, the privacy deadlines. And so I will rise for a short while to permit both of us to do that. What you said about Donna McLean requires me to go back to my team as well, because the same difficulties arise there, and I need to know what the informed answer is.
Thank you, sir. I'm grateful.
So I will rise then for a short time, and we'll resume with these issues when I've done so.
So yes.
May I first of all deal with Helen Steele's position? The inquiry, I'm afraid, is inflexible about the deadline for making applications for privacy over documents disclosed to her by the inquiry. The alternative to her not putting in her applications by the 11th of April is, of course, that the inquiry will do the job itself. But it must, the position must be that either we receive her privacy applications by the 11th of April, or the inquiry will do it itself. As far as the time for witness statements is concerned, what you've said is welcomed and accepted as constructive. I agree that she should have until the 6th of June to provide witness statements. If she can provide them in succession so that there's an earlier one earlier, well and good. But the inquiry could, if it came to a push, live with getting them all on one day. But obviously it would assist, as I'm sure she would appreciate, if she is going to produce two, if we had them successively, the one earlier.
I'm grateful. Thank you, sir.
As far as Donna McLean goes, I'm afraid the position about privacy applications is the same, namely that they must be made, if they're going to be made by her, by the 11th of April. The alternative is that the inquiry will do it itself. If she wants the inquiry to do the privacy applications, rather than put her to the trouble of attempting to do it, then if she lets us know soon, then we can put her mind at rest and the inquiry will be able to get on with the task. The same goes for both, of course, if Helen Steele wants to do that as well. As far as the time for her witness statement goes, I acknowledge that the factors of which you spoke in the private session are powerful, and I will extend the time for her witness statement until the 16th of May.
Thank you, sir.
Now, I think that leaves your three other submissions, is it not? And forgive me if I've overlooked the fact that you've made them and the maths are now determined. But if you want the opportunity to make further open submissions about them, you can. That's Wadsworth, Ruth, and Rosa.
Sir, no. I have no further submissions to make about Ruth and Rosa in open.
Yes.
I made submissions about Wadsworth in open before the short adjournment.
Yes, you did.
Submissions to make.
I thought there was a problem which I had not understood about Wadsworth. I know that there's. I'm well aware of what you've told me in private, but I'm far from sure I have understood the open issues there. And if you would be kind enough to remind me of what they are, I'd be grateful.
Of course, sir. I think I perhaps have been of as much assistance as I might ordinarily be. I was briefed very lately for
Yes.
day for today's hearing, as you know.
Mm.
His witness statement is currently due by the 31st of March. The expected sort is to the 7th of May. The situation with Mr. Wadsworth, as I understand it, is that he has only been provided with documents in which he is specifically named.
Yes.
He has not been provided with documents that name his organisation, that is to say the Anti-Racist Alliance, which he believes are relevant to him. And of course, so I understand that the the position of the inquiry is that such documents as are disclosed are all of those that are deemed disclosable.
Mm.
But in his case, he has been seeking assurances since the 5th of February that those documents that pertain to the Anti-Racist Alliance are not relevant to him.
Mm.
Um, he's had no such assurances. The last letter sent by those who instructed me received no response, so the matter remains unresolved. There was also a secondary, smaller issue that he sought legible copies of 3 pages of particular documents that have been provided to him, and that repeated request has also gone unanswered.
Then I'm afraid I'm going to have to rise to deal very briefly with those with my team because I hadn't got them fully in mind when I spoke about the other matters. As far as Rosa is concerned, by reason of the matters of which you've made submissions in private, there is no deadline of any kind for her witness statement. If she wishes to provide one, the inquiry will gratefully receive it whenever it arrives. As far as Ruth goes, the time for her to provide a witness statement is extended until the 2nd of May.
Thank you, sir.
Then I will rise again very briefly to deal with the Wadsworth question, which I fear, and this is my fault, I didn't have properly and fully in mind. Give me a moment or two. you again. Ms. Johnson.
Thank you, sir.
Wadsworth, the documents that have been provided do include those that are illegible. I agree. We have not got a more legible copy. Printing them out, I'm told, does not make any difference. So I'm afraid that Mr. Wadsworth has got what we can provide him with. As far as ARA documents, it's not intended to serve any ARA documents on him. If and when the issue arises, he can put in a supplemental statement about that. But for our part, I don't think we anticipate there'll be any need for that. I would extend the time for production of the statement requested to Thursday, the 17th of April. That's Easter Thursday.
Thank you, sir.
Does that now conclude all of your clients?
Almost hesitant to jinx it by saying so, but I believe it does so, yes.
Just let me check a moment.
So do we wish to confirm the position with Noel Douglas?
Noel Douglas is the one I was just looking at my notes. Ms. Johnson, Noel Douglas, as I understand the position is that he's asked for and the inquiry have agreed an extension of time, but you haven't addressed it. And is it for that reason?
So I don't have any instructions. I'm receiving some as we speak, if you
Yes.
in a moment. So the instructions that are coming to me are that I don't have instructions. I hesitate to ask again, but in the event that I receive some during the course of this hearing, may I ask to address you on that matter then?
Of course you may. It's more important we get things finally settled than that we do it in a particularly meticulous order.
I'm grateful. Thank you, sir.
Thank you. But unless I hear from you again, then what has been agreed is agreed and no further extension is sought.
So yes, that's the position as I currently understand it, but I my instructions.
So yeah, good. Right. Now, we are now back, I think, with Mr. Greenall and Miss Lewis, unless I'm mistaken.
Thank you, sir. In fact, the remaining clients from Hodge Jones and Allen are all ones which I will be dealing with.
Yes.
So I appreciate that there appears to have been some miscommunication as to what, or misunderstanding as to what was expected on this hearing. But in relation to outstanding clients, I have that there are 15 clients outstanding.
Yeah.
All of whom I ask for an extension until the end of April. The deadlines they currently have all vary, mostly are 31st of March, some a few days sooner, some a few days later. The details for their applications are as set out. They have all made previous applications for extension of time, and the details relating to their personal circumstances are set out in those applications. Shall I proceed to go through them one by one? Is that?
Yes, it is. I think it's important because I don't want to find that when we've finished today, it is asserted that there have been misunderstandings or oversights. I'm determined to do this once and once only.
Understood, sir. So if I might start, please, with Alex Hodson. His current deadline is until the end of March. The extension sought until the end of April. The basis for the extension, given that this is an open hearing, I'll say simply that there is a medical matter relating to a close family member, which has impacted on him and his capacity to work on this. There is also a considerable amount of documentation in relation to Reclaim the Streets, which has an overlap with his own personal statement. There have been issues in relation to the EPIC system. He also has a connection to 56A, and this is the matter which was raised by Ms. D'Agostino in relation to Ms. Wilson. It impacts on him as well. Disclosure for 56A in previous tranches was made, I understand, to Ms. D'Agostino, and that she was coordinating that matter for those persons who were affected by that. And it was therefore anticipated that there was a continuation of that leadership, if I might put it that way. And therefore she had had some dealings in relation to tranche 3, and it was unclear whether the material which had been disclosed to Ms. D'Agostino had also been provided to HJA solicitors in relation to those individuals affected. My understanding is that the material has been disclosed, some of it quite recently, and some of it quite recently to Ms. Wilson. In fact, Mr. Hodson would be in a much better position than Ms. Wilson to deal with those issues arising. And this is one of the sort of one of the discrepancies which has caused some difficulties in responding to the Rule 9 request, because Mr. Hodson is in the position to deal with those 56A issues. He is asked questions about it in his personal statement, and therefore would like to deal with that all in one go, and that supports his application to extend until the end of April. Unless you require further details, those are some of my submissions in relation to Mr. Hodson. Next on my list, I have Brendan Delaney. His current deadline is the 24th of March. The difficulties that he has had is that he's had difficulties accessing EPIC. There has been some of a need to obtain documents which were held at Bindman solicitors by Mr. Schwartz when he previously worked there, which relate to, I believe, the Good Easter Hunt saboteurs case, and seeking access to that has taken some time. Also, in relation to Good Easter, the disclosure has come through in phases to different individuals at different times, and there's been some delay in getting the material together for that. And therefore, for those reasons, I seek an extension for Mr. Delaney until the end of April. The next on my list is Brendan Mee. The reasons in his case are similar to Mr. Delaney in terms of Feynman's documentation, EPIC issues, Good Easter Hunt sab issues. He also has had work commitments which have affected his ability to work on his statements, and issues in relation to his family, which have been identified, I believe, in correspondence seeking extensions of time. And so for those reasons, in his case, I seek an extension until the end of April. Brian Healy is the next core participant. Current deadline, end of March. Mr. Healy has unfortunately suffered a bereavement in his close family, and that has had a significant impact on his ability to work on his statement. And for that reason, I asked for an extension until the end of April. Next is Miss Wilson, who of course was mentioned by Ms. D'Agostino earlier today. My understanding is that she has a current deadline at the end of March for her original statement, but then she has recently been provided with further disclosure and a further supplementary Rule 9 request, which was received on the 13th of March, and an extension of the deadline until the 3rd of April. Again, in her position, because of the short deadline for the disclosure of the new statement, also she has had difficulties accessing her own personal documents due to building work taking place in the location that they're stored at. So that's added to the delays in her case, and also she has an interest in Reclaim the Streets, and there's a lot of documentation provided for Reclaim the Streets, which overlaps with her document. So again, in her case, I asked for the end of April. I can indicate that everyone I'm speaking on behalf of is working hard on their statements, and you know, if people are in a position to submit earlier, then they may be able to do so. But the request on behalf of Ms. Wilson is until the end of April. The next I have is the Genetic Engineering Network. Again, current deadline is 2nd of April. Request until the end of April. There's been a delay in accessing the documents for some of the persons involved. And also there are a number of individuals needing to coordinate in relation to that statement.
You said that the current deadline is the 2nd of April. That was an extension that was requested, which the inquiry legal team agreed to.
Yes, sir. I accept that, and I am making a further request for an extension until the end of April.
Well, on what basis?
On the basis that there have been difficulties in accessing material for some of those persons involved, and the need for the because there's more than one person involved, coordination and the like adds to the difficulties in preparing the statement. Okay. Good Easter Hunt Saboteurs is the next group. Current deadline is 31st of March. The reason for seeking a further extension until the end of April is, as has been indicated for some of the earlier clients, some of the material was held by Bindman solicitors, and there was a delay in getting access to that. The disclosure in relation to Good Easter Hunt Saboteurs has come through in various stages, and there is also my understanding that some of the material that's been provided to the Hunt Saboteurs Association is relevant to the Good Easter Hunt Sabs statement. There's a crossover of issues there, and there are a significant number of different persons involved in producing that statement. Again, need to coordinate between the individuals so that a group position is put forward. So for those reasons, I seek an extension till the end of April. GRD has the current deadline of the 24th of March. Again, I seek an extension to the end of April. He had difficulties accessing EPIC. There was difficulties getting documents from Bindmans. He had delays in getting access to the Good Easter Hunt Saboteurs material. He's had work commitments. He's also been traveling outside of the country, which has made delayed work on the statement. And I don't wish to go into details, but there's been some medical issues as well, which are set out in personal correspondence. And so for those reasons, I seek an extension to the end of April. The next client, this is number 9 on my list of 15, just so you know where I'm going. Next client is Jane Laporte. Current deadline, I understand, is the end of March. she had issues with Epic, including documents which were not restored after the Epic system came down, and that delayed work for her. And she also has work commitments and limited time to work on this statement. And for that reason, I seek an extension. Jay Jordan, who is has a connection to Reclaim the Streets. He has the similar issues as Jane Laporte. He also suffered a bereavement in his immediate family, which of course has meant that he's had other issues to deal with. He has also, he works often abroad, and traveling commitments for work have limited his capacity to work on his statement. And also, as I think has been outlined in personal correspondence, there are some personal medical issues which have been affecting him. And for those reasons, in his case, I seek an extension till the end of April.
Yeah.
Martin Shaw is the next client I have. Current deadline 31st of March. He had, there were issues arising in relation to disclosure relating to the genetic engineering network. He is in a position to provide a significant information in relation to that. There have also been some significant issues that have arisen in relation to intimate relationships, and that is another matter which has required some further work on his statement. And for those reasons, I seek an extension until the end of April. Next on my list is Matt Salisbury. The issues in relation to him, his current deadline is the 28th of March. He is another client who has connections to Reclaim the Streets, a significant amount of documentation there, and work on the Reclaim the Street statement obviously has an overlap with his own personal statement. He has had the similar issues in relation to access to documents on Epic, and other personal commitments similar to some of the other clients, such as Jane Laporte. And for those reasons, I seek an extension until the end of April. Number 13 is Robert Banbury. Again, current deadline at 27th of March. Another client has connection to Reclaim the Streets. He's had difficulties accessing Epic. He's had also required access to material that was held by Bindman solicitors in relation to some quite significant matters in his Rule 9 request. And for those reasons, I seek an extension until the end of April. Roger Geffen, current deadline 31st of March. He has been away out of the country for some time during the period when he would have been required to work on his statement. There's been a large amount of material in relation to Reclaim the Streets, and he has personal commitments which have limited his ability to work on the statement. And again, for those reasons, I seek an application until the end of April. And then the final client in this category is Simon Taylor. He is a Good Easter, is connected to Good Easter Hunt Saboteurs. Current deadline is end of March. He has pre-booked holidays in this period. He also has very significant work commitments, and he didn't get access until the Good Easter Hunt saboteur disclosure until I understand the 19th of February. So there was a delay in him getting access to some of the relevant material. He now has it. Again, in his position, for the reasons given, I seek an extension of time until the end of April. So I think that covers the outstanding clients from Hodge, Jones and Allen. I addressed you already on Reclaim the Streets and Paul Gravett. And in relation to Ben Leamy, so you mentioned that there was an issue in terms of the downloading of documents. I don't want to go too much into this matter in an open public forum, but Mr. Leamy's position is that he told the inquiry, he was given permission to download documents, and he told the inquiry what documents he had downloaded. And if there was any issue over exceeding the scope of what he was permitted to download, that came to light because he had been open with the inquiry and told them what he had downloaded. He has been out of the country, and that is maybe there may be some issues arising from that, because I understand the inquiry wished Hodge, Jones and Allen solicitors to see him in relation to some of those issues. But his position is that he told the inquiry what had been downloaded, and it can ensure that there is compliance going forward. He has had very significant difficulties in working with the material on the EPIC system. He says that when he was able to download it, it made it much more easy for him. He was able to search and sort documents in a much more efficient manner than he was able to using EPIC. That has all been paused because he's been asked to delete the material he's downloaded, etc. So that is what I would wish to say at this point on that matter. If there are other matters arising, then I would ask to address you in a private session. But on his behalf, I seek an extension for those reasons and the reasons outlined earlier until the end of April.
Forgive me if I've misunderstood or overlooked something, but is Asa Winstanley on your list?
Not immediately, sir. I can, if might I just take instructions very briefly. Thank you.
Might I just take this opportunity to say that from our point of view, tracking these applications, the question on our mind is whether there is an application going to be made on behalf of Maya. We were anticipating that.
That was next one on my list.
Mr. Atif Chowdhury. And then there is a question. We know there's an application on behalf of Dr. Lawrence, and the question is whether that's going to be dealt with on paper or orally.
I think one of the issues may be that I've been making submissions on behalf of core participants represented by Mike Schwartz at Hodge, Jones and Allen. I think there may be some other core participants from others. I don't want to delay matters right now. If there are others to make submissions, perhaps I could have a short amount of time to get instructions as best I can on those on those individuals. It was Winstanley, Maya, and was a
Mr. Atif Chowdhury and Dr. Lawrence.
Dr. Lawrence. Okay. So might I just have some time just to take instructions on those, because those weren't on my list.
Yes, as far as Dr. Lawrence goes, I know a good deal about his circumstances. At present, the inquiry cannot accept the suggestion that he's made, and his circumstances need to be addressed.
So that's heard. I'll make inquiries.
Then I will rise now to deal with the submissions that you have made with my team, and you will let me know when you're ready to resume with those that we haven't dealt with.
Thank you, sir.
Thank you.
We're ready to resume, sir.
Thank you. Mr. Greenall.
Thank you, sir. I have managed to take some very brief instructions in relation to the four outstanding clients. Those are persons who are represented by other solicitors at Hodge, Jones and Allen, and
Yeah.
that is the reason why I didn't have instructions.
That is what I thought. Can we pause there for a moment, because I am going to to announce decisions made in relation to all but three of those whose cases you have addressed, and will invite you, if you wish to make further submissions privately about three others. As far as those that you have addressed in open and where I have made decisions in the following order: Brendan Delaney must produce, the time for his witness statement is extended to the 11th of April. Brendan Mee, extended to the 11th of April. Carolyn Wilson, extended to the 4th of April. GEN to the 4th of April. Good Easter Hunt Saboteurs to the 11th of April. GRD to the 11th of April. Jane Laporte to the 4th of April. Martin Shaw to the 4th of April. Matt Salisbury, Robert Banbury, and Mr. Geffen to the 2nd of May. Simon Taylor to the 11th of April. Brian Leamy to the 11th of April. Paul Gravett to the 2nd of May. There are three that I invite you to make private submissions about if you wish: Alex Hodson, Brian Healy, and John Jordan.
Thank you, sir. If I may make those submissions in private.
Certainly. Now, would you prefer, it would suit me better if you were to deal with the open submissions that you're going to make for the three or four other of your instructing solicitors, clients, and then go into private.
Yes, the submissions, I can certainly do that, sir. Dealing first with Dr. Lawrence.
Mm-hmm.
So, as I hope you're aware from written correspondence, he's resident in Jamaica.
I know that.
He's obviously of some age. He has difficulties accessing using computer, and also there is difficulties getting reliable internet access. And in terms of people to assist him, they are limited, and they have their own commitments in terms of work. In practical terms, the only feasible way for him to produce a statement is for him to meet with those instructing me, for them to go through the documents with him, and to help him prepare his statement. He is, because of matters arising from the hurricane in Jamaica and things he has to take care of, he's not returning to the UK until late April. An extension of time was sought until the 13th of June, and I understand was not granted by the inquiry legal team. The position is that for he wishes to participate in the inquiry, to assist the inquiry. He obviously has important evidence to give, but until he is in the United Kingdom, it won't be possible to make progress, and therefore I would ask that for an extension. If the 13th of June is not possible, then at least to the end of May.
Now, because of his unusual circumstances, I will need to consider with my team whether or not, in his case, I make a decision today, or alternatively, deal with it on the papers when we know more about his ability once he's returned to the United Kingdom. But I do appreciate the difficulties of which you've spoken. You rightly point out that he is a person of great interest and importance to the inquiry, has an important part to play, and I wish to ensure that he is able to do it. But would you allow me and my team to reflect briefly on that before either making a decision or saying we will deal with this on the papers?
Of course, sir.
Now, that then leaves the three from the ISM.
Yes. So in relation to Mr. Chowdhury, I understand that an application was made in writing, setting out the position that he is in. There have been emotional difficulties in addressing.
They have been set out in the document, and there's no need to go into them unless you wish to in public. I'm bound to say I was surprised when I read the document about difficulties other than the normal ones, but put that to one side. I know what they are.
Yeah. Well, it's on those bases that I seek an extension of time till the end of April. I'm receiving instructions as I speak, sir.
Yes.
The okay. In relation to the other two clients, it is the process of going through relatively numerous documents, including documents they themselves have in terms of their own material, which is taking time. And again, for those reasons, I seek an extension until the end of April. Beyond that, I don't have anything I can add to the emails, written submissions which were submitted in email to the inquiry.
No.
I should say that those instructing me in relation to these four clients hadn't realised that it was necessary to have an advocate here, and they apologise to the inquiry and have cooperated as best they can.
They don't need to apologise at all. These difficulties arise, but what is important is decisions, not how we get there procedurally. Maya?
I'm afraid I don't have any additional instructions in relation to Maya, so I'm not in a position to make any submissions, sir. My understanding is that there was an application was sought for all clients until the end of April.
Yes.
Yes.
Okay. Well, I understand what the position is. I want briefly to speak to my team about that. But before I do that, I want to give you the opportunity of making submissions in private.
Please, if I could, very briefly.
Yes.
Jo said she's checking.
So we'll need 5 minutes just to confirm the attendance of those private hearings. So I'll pop you in your breakout rooms and I will await further confirmation. Thank you.
Okay. Mr. Greenhall.
Thank you, sir. I've got no further representations to make other than those in the private session.
Thank you very much. In which case I will announce the decisions. I deal first of all with Dr. Lawrence. I cannot extend the time for submitting privacy applications beyond the 11th of April, but I appreciate that he has certain logistical difficulties in Jamaica. And could you tell him that the inquiry is perfectly happy to do the privacy applications? There are several obvious egregious applications that must be made, but it would assist the inquiry if he is unable to do it himself while in Jamaica, if he could let us, through those who instruct you, know that that is the case, and the inquiry can then set about it immediately rather than waiting until the 11th of April.
Understood, sir.
As far as the provision of his statement is concerned, he will have until the date that he has requested, the 13th of June, in which to provide it. Can I now turn to Maya and Jay Jordan and Mr. Hudson, Mr. Healy? For reasons that I understand and which you have explained to me in closed session, Mr. Hudson, Mr. Healy and Jay Jordan will all require until the 2nd of May to produce their witness statements, and I extend time for them to do that. I understand from what I know that Maya has a large number of documents which she has to examine and to exhibit to her witness statement, which will take her time to sort out. And in her case too, I extend the time for service of her witness statement until the 2nd of May.
Grateful.
As far as Mr. Chowdhury, Mr. Winstanley, and MCD are concerned, the time for their witness statements will also be extended until the 2nd of May.
Grateful, sir. Thank you.
I think that deals with all of your clients now, does it? Including those that you acquired during the hearing?
I think so, sir. I think so. Thank you.
Good. Thank you. I understand that Imran Khan and partners are now available to make submissions. If that is right, could I ask, please, that they speak up and come on the screen?
Good afternoon. Thank you, sir.
Thank you very much for coming at short notice. And maybe that you didn't appreciate that this was the day for deciding questions, but now that you do appreciate that, I'm grateful to you for coming.
So may I, forgive me for interrupting, but I understand there are good practical reasons why it would be better to allow Ms. Johnson to make her sole outstanding submission if we might interpose her.
Of course. Then my apologies to you.
No problem.
Yes. Ms. Johnson.
My apologies.
Not at all.
To you all. I'm grateful to my learned friend, Mr. Barr. At some point, I will run out of backup childcare options. We're not quite there yet. But at some point, I may need to beg you to forgive my discourtesy and release me early.
Of course.
We're not there yet.
You do not need to ask. Please leave when you must.
I'm grateful, sir. Of course, I would wish to stay to hear all submissions, but when the time comes, I will.
Understood.
So to clarify, there are no outstanding applications to be made in respect of Noel Douglas, but there is one, if I may, very short application I'm now instructed to make on behalf of Guy Taylor, who is a Category K core participant.
Yes.
So his current deadline is the 28th of March. The extension sought is until the 18th of April. And the reason, which I can give more detail on enclosed if required, but I hope that won't be necessary, is that he has suffered a an extremely close personal family bereavement.
Yeah.
The funeral for that person will be on the 7th of April. Mr. Taylor's confident he'll be able to complete his statement by the 18th of April deadline he now suggests, but asks that he be granted that extra time to allow him to grieve.
I do not even intend to rise to consult with the team. The answer is yes.
I'm grateful.
And thank you for your assistance today. And as I say, please feel free to leave whenever you wish.
I'm grateful. Thank you, sir.
Right. Apologies for mispronouncing your name, Ms. Alshkili. I got it right?
Al-Shakili, thank you, sir.
Alshkili, I do apologise. I did mispronounce it.
Thank you, sir. I'm making these submissions on behalf of our co-participants, Baroness Doreen Lawrence, Mr. Dave Smith, Mr. Dan Gilmond, Mr. Frank Smith, Mr. Steve Headley, Lisa Tushore, and Mr. Aikenson of the Blacklist Support Group, and Mr. Suresh Grover of the Monitoring Group. Together our co-participants. I do not intend to repeat the written submissions we provided to the inquiry team on Friday. However, I wish to make additional further submissions in relation to a few of our co-participants. To assist, I will follow the same order of we have listed and included in our written submissions. So the starting first is our co-participant Baroness Doreen Lawrence. I do not wish to repeat the reasons why we are seeking further extension of time for Baroness Doran, but to bring to your attention, sir, that we emailed the inquiry. So there's an outstanding point in relation to the disclosure released for our co-participant Baroness Lawrence. We emailed the inquiry team on the 4th of March, explaining that only a small percentage of the disclosure, if any, relates to the SDS reports or information prior to 1998, in the years immediately following Baroness Lawrence's son's Steve Lawrence's death in 1998. We have yet to hear back from the inquiry team, so this remains unanswered. And of course, it's imperative today to understand the inquiry's team position in determining whether the deadline we saw at the end of April is actually a workable deadline.
Yes, so that I understand the point, you have been told by the inquiry team that there are additional documents relating to what precisely?
We haven't received any response from the inquiry team, but we've raised the point that as far as we can see, all the documents relate are after the 1998. So there's no documents to prior to 1998 and immediately after the years following Miss Baroness Lawrence's son's death, 1998. So this is the first outstanding query, sir. The second I should move to, it's in relation to our co-participant, Mr. Dave Smith. And I don't wish to repeat the point in paragraph 10 of our submissions on page 3, but in summary, it is we've identified that he has there's a reference to an SDS file in his name from 1986, and we've asked the inquiry to investigate whether we will be provided with additional and further disclosure. Again, this is imperative today because it will determine whether the deadline of the end of April is a workable deadline. Thirdly, I wish to move to our co-participants, Mr. Suresh Grover. For Mr. Suresh Grover, we wrote to the inquiry team. We've sent them a letter on the 25th of February 2025. We understand that, as far as I understand, we were told that we will hear back from them, but we've yet to receive a response. And in our letter, of the 25th of February 2025, we outlined why our co-participant, Mr. Grover, believes that he is required additional disclosure. In particular, it is in relation to his surrounding apologies. For Mr. Suresh, it's we require the inquiries and explanation why disclosure made in respect of him and a related group, the monitoring group, is largely limited to events surrounding the Steve Lawrence inquiry.
Yep.
Okay. Thank you, sir. And the two additional. So again, on just to conclude on our co-participant, Mr. Suraj Grover, again, it is imperative we understand the position if we will be provided with additional disclosure to help us determine whether the deadline of the end of April is a workable deadline. The two further submissions I wish to make are in relation to the group statements required on behalf of the first group it's the Black Support Group, which is, and the second statement on behalf of the monitoring group. For the first one, the Black Support Group, the disclosure was provided in sometime in February with 6 weeks time. The deadline for their group statement is on the 7th of April. In relation to the monitoring group, their deadline is on the 3rd of April to provide the group statement. However, I wish to draw your attention and to ask the inquiry team to refer to our letter dated the 24th of May of last year, where we've made a specific disclosure, request for specific disclosure, and listed out different groups that our clients, for example, the monitoring group, have played an active part in a number of campaigns from 93 to 2007, and the same goes to our to the Black Support Group. They have played an active part in a number of campaigns from 93 to 2007, but yet only provided with a disclosure related to their group, which was formed in 2009.
I will have to consult my team about additional disclosure. The usual starting position is that the inquiry has disclosed, save I know it hasn't in the case of Baroness Lawrence, all of the documents that it has in its possession which it considers relevant. And if that were to be the position, then what would the applications be?
The application be, I mean, if that's the position, we will get a confirmation today, and we will agree a deadline. The deadline will be the end, what we sought, which is the end of April. But we were seeking your confirmation that this is the position, because we've not heard back from the inquiry team.
Then I will have to rise to discuss that with them. There, I think, are other Imran Khan clouds that you haven't mentioned.
That's right, sir. I've not mentioned because I do not intend to make oral submissions. We've given, unless you want me to repeat the points in relation to each co-participant. I'm happy to do so if you wish.
I better, just for the avoidance of doubt, ensure that I have got them in mind. They're Dan Gilman, are they not?
So firstly, Paranas, yeah, the ones we've not talked about, Dan Gilman, co-participant Mr. Dan Gilman, co-participant Mr. Frank Smith, Mr. Steve Headley, Miss Lisa Tiosha,
Yeah.
Mr. Steve Akeson. That's all, sir.
Very well. Forgive me while I go and discuss these matters with the inquiry legal team.
Grateful, sir.
Ms. Al-Kasili, hope I've got the name right.
Al-Shakili, yes, sir.
Al-Shakili, thank you. I will announce the dates in a moment, but I would like to clear up what may be a misapprehension among some of your clients. In the case of Baroness Lawrence, there are 20 or 30 documents. They either have been disclosed or are about to be disclosed to her, but there are not at the moment any other documents of which the inquiry is aware, which might affect her ability to produce a witness statement. The inquiry is always on the lookout for additional documents from within the police service, and I cannot promise that none will turn up, but they have been carefully looked for, and I'm told that there is no reason to believe that there are any. But that does not preclude entirely the possibility that there will be some. But that cannot hold up the conduct of the inquiry, otherwise we will never finish. And therefore, although some of those who we represent may feel that there are documents to be disclosed to them, I'm afraid I cannot allow that to delay the production of witness statements by them. It is, as I say, inevitable that when the hearing bundle is produced, that some of your clients will see in it documents relate to activities and groups that they recognise and may well have participated in. And they may, at that stage, wish to say something further about it. They'll be afforded the opportunity of doing so. But it must not hold up the submission of the Rule 9 witness statement at this stage.
Understood.
As far as Baroness Lawrence is concerned, the time for the submission of her Rule 9 statement is extended to the 2nd of May, as it will be in the case of Dave Smith, Suresh Grover, the Monitoring Group, and Steve Headley.
Mm-hmm.
As far as Mr. Gilman is concerned and Frank Smith is concerned, their time for service of a statement will be extended until the 4th of April, but not beyond then. They have had the request and the documents for a long time now. Likewise, in the case of Steve Aitchison, his time is extended to the 4th of April, but not beyond. He's had no documents because we haven't got any. Lisa Teuscher or Tuscher, I understand the personal difficulties that she is in, and the time for the service of her Rule 9 witness statement will be extended to the 25th of April. I think that deals with all of those that you represent on who.
Oh, we're missing the Black Support Group statement.
The Black Support Group has merely been requested, as I understand it, to provide an impact statement. There is no request for a Rule 9 statement from the Blacklist Support Group. Dave Smith, I think, has been asked to say something about them, but if he wants to, but that is all. The Blacklist Support Group, I'm sorry, has not, as I understand it, had a Rule 9 request made to them, and nor, as I understand it, are they core participants, but they feature, I'm afraid, a very long way down the chain of those that the inquiry must investigate to produce a report.
Thank you, sir. Just to go back, please, to Mr. Our co-participant, Mr. Frank Smith.
Yes.
I note what you say about he had enough time, but just want to reiterate the point we included in our written submissions.
Yes.
We asked the inquiry team we applied to the inquiry team to grant him permission to print and download documents on EPIC.
Yes.
And only last week, Thursday, on the 13th of March, when he visited our offices, he successfully collected physical copies of his documents. So I'm afraid I'll be grateful to request additional time in his circumstances.
How many documents were there?
I want to say roughly about in the circle of 500 pages.
Ah, I had not appreciated that there were that many documents. In that event, I don't need, I think, to consult again with my team. I would extend his time for producing a Rule 9 witness statement until Monday, Thursday, the 17th of April.
17th. Thursday, the 17th of April, correct?
Yes. Yes.
Thank you, sir.
Don't set it on Good Friday because that is
Yeah,
the day is known.
understood.
Thank you
Grateful,
very
sir.
much.
Thank you.
Now, now is the time when Ms. Steele and Mr. Morris should make submissions on behalf of the McLibel support campaign if they wish.
Thank you. In relation to McLibel, I wanted to say that while I'm glad that we now have the opportunity to be heard, this hearing, with all the stresses and time taken up, wouldn't have been necessary if there had been earlier and proper engagement with non-state core participant concerns. And I wanted to urge a more collaborative approach going forwards. And, you know, non-state core participants have waited years for disclosure, yet we were then only given a matter of weeks to respond to that disclosure. And with both statements and any privacy applications, many of us are impacted by the trauma of the deception by the undercover officers and the abuse some of us were subjected to. It's already stressful engaging with the inquiry, and the impact of short deadlines causes intense additional and unnecessary stress. And it also feels extremely disrespectful of our own lives, particularly bearing in mind how long we've already waited. We want to assist the inquiry, but quite often it doesn't actually it doesn't actually feel like the inquiry wants us to assist the inquiry. I have to ask why the inquiry didn't consult with us prior to the deadlines being set. And as I say, I urge a more constructive approach from now. The specific situation with McLibel support campaign, I made an application for us to be granted core participant status. That was granted. We haven't had a Rule 9 as a group, but I do wish to make a statement for McLibel. There were, in tranche 2, I had a personal Rule 9 that had more than 400 questions, of which about 75 were about McLibel. In tranche 2, McLibel, there were 112 documents, 2,286 pages. They were disclosed over a period of 10 months, more than half of them coming long after my personal Rule 9 was served on me. So I haven't had the time to go through those documents. I know that it may seem like there's been a long time since that disclosure was made now, but in reality, I have been engaged with following the hearings in tranche 2. Many of the witnesses who gave evidence relating to me. They talked about me and or they talked about issues that are very relevant to me, such as other women being deceived into relationships. So it's not the case that I was able to work on this, during the last period, the last year the last however many months when the inquiry was running. Obviously, well, the inquiry is aware of the impact of the procedures on me. That also prevented me from working on the statement. So now in tranche 3, we've had another 51 documents served for McLibel on the 28th of February. That's on top of my personal disclosure that was made on the 21st of February, and that for Reclaim the Streets, my personal disclosure being 164 documents with 800 approx pages, and RTS disclosure being 690 documents, nearly 2,000 pages. It's a very tall order to get on top of that amount of disclosure. And it's made even worse by the fact that it doesn't appear to be standard practice for the inquiry to serve an index of the disclosure that can be sorted as a spreadsheet, that can be sorted by date or by officer, to facilitate being able to work through the documents in some kind of systematic way. I requested that index, and it was another 2 weeks after the disclosure was made before it was provided, and I've still had to work on it in order to. I don't know what was up, but there was considerable formatting problems that meant that it couldn't actually be sorted into date order, that I had to work on to correct that. I still have several thousand pages from tranche 2 to deal with, including the 2,000 from McLibel. And I also, on top of that, have my own contemporaneous documents that I want to assemble, some of which I believe are actually really quite important for the inquiry. I understand the concerns of the inquiry relating to privacy and the bundle, but the consequence of requiring privacy applications by the 11th of April is that it will effectively mean that I will have to stop work on the statement, and it will also impact on my ability to do a McLibel statement as well as the personal statement relating to Muscat. I wanted to say that there's a very real problem with the inquiry approach to privacy, in that there's no transparency about the process and no discussion or negotiation around our concerns. To give you an example, in terms of egregious privacy, I've recently had a whole lot of documents disclosed, which were disclosed to other people, despite the fact that it included names and photographs and addresses and phone numbers of members of my family. And the only privacy redactions that were made were in relation to my national insurance number, which frankly I couldn't care two hoots about. Yet there was no privacy redactions over all my family's personal details and photographs. There has to be some kind of workable. There seem to be no written guidelines that are adhered to in relation to what the inquiry considers to be matters that need to be redacted to protect people's privacy. And I would urge the inquiry to bear in mind that the whole reason this inquiry exists is because we have already had our privacy massively interfered with. And so it's particularly distressing that the inquiry appears not to take seriously our need for privacy now and our need for time to be able to deal with that, and to deal with it in a constructive way, rather than just setting arbitrary deadlines and what feels like a threat, what basically amounted to a threat last year, me having waited an additional sort of 9 or 10 months on top of the already long delays for any disclosure, an additional 9 or 10 months in my disclosure to have it completed beyond when it was supposed to be completed, and yet I was required to make privacy applications during the month that I was supposed to be on holiday with my mum for her 90th birthday. And then the inquiry, because I said, look, it's impossible for me to deal with this, the inquiry then said, we'll do it for you. But the approach that the inquiry took was to not consult with me about how that was done. And while we are expected to individually list every word that we want to have redacted, what the inquiry team did was send me a new copy of each document and tell me I had to compare line by line the original version they disclosed with the new version. Like, if it couldn't have been a more impossible task, even if there'd only been, 100 pages. In reality, there were thousands of pages and it just wasn't possible. It felt utterly disrespectful and distressing. And I do urge the inquiry to take this, the privacy concerns of non-state core participants seriously and afford us sufficient time to do it properly. It will be more efficient in the end. I understand the inquiry wants to get the bundle done by a certain time, and I agree that that's important, but I don't actually understand why this wasn't discussed with us and factored in before the hearing date was set, if that was the case. But secondly, also, in reality, the inquiry cannot actually deal with everybody's privacy redactions at exactly the same time. And for that reason, I would ask that if there are specific documents that the inquiry wants to deal with early on, then the inquiry makes us aware of that, makes me aware of that, and I will do my best to attempt to do those specific documents, perhaps statements early on. But to expect me to be able to deal with thousands of pages just means that I have to read everything twice, when in fact I think that those applications for privacy will just be sitting on someone's desk for quite a long time after the 11th of April, simply because they can't all be processed at once. So I would urge that that is revisited. I just wanted to say as well, because I know that other people have struggled with EPIC to a huge degree, and that one key thing that would make the process much simpler and easier for everybody is that, like, where core participants have more than, for example, 30 documents, the inquiry provided as standard an Excel spreadsheet of the disclosure to them that gave the control number and the date of the document, and as they did in tranche 2 for me, also included the relevant officer number alongside it, because that means that we can sort the disclosure list into an order that actually makes it possible to work on the documents in some kind of coherent way, rather than as present, just getting them in completely random order. And it just wastes so much time, us having to construct lists and cut and paste. Well, we can't even cut and paste, type in individually all the control numbers in order to be able to look at the documents and make notes about them. Anyway, I think that's, I do want to make a statement on behalf of the McLibel Support Campaign, even though we haven't had a specific Rule 9 request. We were granted that status. There is clear, serious and unnecessary intrusion into the McLibel Support Campaign and interference with the McLibel case, breach of privacy, breach of legal professional privilege, and so on. And I think that needs to be addressed properly in a statement from the McLibel support campaign. I'm sure Dave's got more to add anyway. Thank you.
Thank you. Mr. Morris.
Yes, I'll try and be brief. Obviously, I agree with everything that Helen said. Obviously, we also appreciate this hearing, and it's something that we did call for with the statement by 92 individual core participants. We called for, proper dialogue over these issues. So we're pleased that this is happening, and pleased with the chance to speak. And we do want to continue to collaborate constructively, as we have done from the beginning of the inquiry. We have been raising for many months the need to have T3 joint meetings with the T3 team to iron out some of the issues that are now raised their ugly head over the last few weeks. And those meetings have been put off or refused. And as a result of our concerns, we and our lawyers have been calling for T3 to be put back. So we were very pleased when it was announced on the 7th of February that the next round of hearings would be postponed from April to October. And it said on the UCPI website, quote, to allow adequate time for witnesses, core participants, recognised legal representatives, and the inquiry team to prepare their evidence. So we were very pleased when we read that there was going to be 6 months for that purpose, additional 6 months for preparation time. And then we were told, well, our actual preparation time wasn't going to be increased. It was still just 6 weeks. And I just want to emphasize, you can imagine how angry everybody must have been when they read that. Absolutely livid. And there was no other mechanism, having communicated by email and through the lawyers trying to get T3 meetings organised. There was no other mechanism except to do an open letter. And we're glad that at least this hearing was scheduled, and at least we've been able to address some of these issues mainly about the arbitrary 6-week deadline that was previously being imposed. Just want to say a few other bits and pieces. Yes, I think, I'm not sure if you are aware of just how much chaos we believe is happening inside the inquiry legal team. There's a whole range of issues from, as you've heard about EPIC, lack of responses to emails. You've heard of some of those issues. That's widespread. Contradictory replies. The indexes not having the dates on, which is a deterioration from the previous T2 organisation of the material. And the disclosure to groups. Disclosure is clearly a fundamental legal obligation, and the fact that it's very arbitrary which groups are getting disclosure, as we've heard from about Mark Wadsworth not getting the disclosure despite being the chair of the Anti-Racist Alliance. So I think there's some issues that need to be sorted out with respect behind the scenes, because we believe that corners are being cut and there's pretty much a lot of chaos as far as we can see from our side. I might be wrong, but I think it needs to be investigated and improved. And all of these individual applications that we've been asked to make over the last few weeks have been a colossal waste of time to everybody, to ourselves, our lawyers, to the ILT, and so on. So at least now we've addressed it in one day, and so on. We feel that the 2nd of May, we called for a 30th of April minimum deadline, and we feel that 2nd of May is a reasonable deadline, and we feel that's a sensible one to apply you know, as a minimum to everybody. I understand that some people have been given earlier deadlines and some people have offered earlier deadlines. And where we can try and get material in earlier, I'm sure we will do so, because we are committed to a successful inquiry. So finally, I just want to say that we want to work collaboratively together. I think it's really important to resume the regular T3 meetings as we had throughout T2, where a lot of these issues were addressed. Throughout T2, we had very constructive weekly or fortnightly meetings with the team. And we were able, obviously, as a litigant in person, I was part of those meetings with the lawyers, and I could bring matters forward that I'd been asked to do so from other core participants. So I feel like let's get the T3 meetings going as soon as possible. Let's learn from T2 and let's get the show on the road. Thank you.
I respond to your last point. The meetings will be resumed. The meeting, the latest one fixed, was cancelled because today's hearing was fixed at the urgent request of a large number of signatories, 92 individuals and 20 groups. And I will have something to say about that in a moment. But that is the reason why that meeting was cancelled. Today has proved a useful exercise, as I'm glad you've acknowledged. I make it clear, I repeat what I've already said, that the time for dealing with applications for privacy redactions over documents disclosed by the inquiry is not going to be extended beyond the 11th of April. I'm glad to hear from you that the 2nd of May is an acceptable date for the provision of witness statements. In the case of Helen Steele, that has been extended at her request to the 6th of June. Thank you both. And that, I think, apart from Kirsten Heaven perhaps being offered the opportunity of making a short statement at the end, concludes today's proceedings.
So I wonder whether I could come back to you about the issue of cutting and pasting in EPIC. It seems rather a small technical detail after everything we've heard, but it is an important and,
unsurprisingly, I got it wrong. I am not the person to deal with technical issues.
So you got it wrong, but you are capable of making what you said right. And I'd ask you if you could arrange for EPIC to enable us to cut and paste all the documents.
I will certainly ask, but I cannot, from my own knowledge, as is obvious, give you the answer, and I don't know what it may be. But I will certainly ask.
So perhaps I can interject.
Yes.
My understanding is that you can cut and paste from the index. You can cut and paste from the Rule 9 request. You cannot cut and paste from the documents. And I understand that changing that is, as best I understand it, something that cannot be done because of the way the documents have been, and I think the technical term is flattened. So that is my understanding. Of course, we can double check that and confirm it, but that is my present understanding.
I would be very grateful if you could, and maybe they would know how to unflatten a document.
I am not going to intervene further in this discussion. Thank you. Ms. Heaven.
Thank you, sir. Good afternoon. I appreciate it's late in the day, so I'll keep it short, just some short points. So you clearly have my written submissions.
Yes, they were very helpful. I read them with interest and they were constructive, and I'm grateful for you.
So today's hearing was prompted by the open letter that was published by over 90 non-police, non-state core participants who were facing intolerable pressure, some of which you've heard about today, and stress arising from the unrealistic deadline that was unilaterally imposed by the inquiry for the provision of Rule 9 witness statements. And as you know, and you've just heard from a moment ago from Mr. Morris, this led to multiple time-consuming requests for extensions of time. Now, the general position of all non-police stakeholder participants is that they want to be asked to do things within a realistic and a fair deadline, and in a way that does not lead to individual core participants being singled out or required to make individual applications for more time, often in reliance on difficult personal circumstances. Now, of course, there clearly may be circumstances where this is unavoidable, but as a general rule, it is the position of the non-police stakeholder participants and their request that they ought to be subject to the same fair and reasonable deadline. Ultimately, this will reduce delay and unnecessary stress and unnecessary applications at a time when serious work clearly needs to be undertaken. Now, as Mr. Barr rightly acknowledged at the start of this hearing, it is of critical importance to this inquiry that it receives the best evidence it can from the non-police stakeholder participants. The non-police stakeholder participants wish to make the point that whilst there is clearly pressure on the inquiry to report as soon as possible, obtaining the best evidence means that everybody engaged in this inquiry needs adequate preparation time and not just the inquiry itself. The non-police stakeholder participants ask that lessons are learnt from what has preceded today's hearing so that unrealistic deadlines are avoided in future. And for this to happen, it is critical that the inquiry continues to adequately and regularly communicate with the non-police stakeholder participants. And I know that they will be heartened by your comments a moment ago about the meetings resuming, the regular meetings resuming, because as you know, that is something that it did assist in tranche 2, albeit there were some disagreements, but ultimately it did assist. So the non-police stakeholder participants wish to emphasise, and you've heard this from a number of representatives today, that they do remain committed to engaging with the inquiry, but this also requires the inquiry to adopt a fair approach in its treatment of non-police stakeholder participants. And one of these approaches is being consistent with a trauma-informed approach. So it's noted today that you have granted some realistic extensions of time for service of Rule 9 statements. Now, so I've addressed in the written submission some of the practical issues being caused by EPIC, as well as the way in which disclosure has been clustered and indexed by the inquiry and how this is causing delay. And you heard some more examples this morning from Ms. Dighton and again just a moment ago, and helpfully some matters were clarified. But if I can just make a few more short points to see if improvement can be made so that work can be sped up. So if you can just bear with me, I'll only be a few moments and I might get a little bit technical, but this is obviously not just for your benefit, but also for the benefit of those listening. So the functionality of EPIC is poor, particularly when compared to Opus that, as we know, was used in tranche 1. This is not an overstatement of the position, but it is the reality. But this difficulty is combined with how the inquiry has documented and described the disclosure on EPIC. So, for example, each document on EPIC has a properties section, which we understand is manually populated. This section includes things like the control number and a description of the document. However, when the properties section was populated, the date of the document and the nominal of the officer who the reporting related to was not inputted into EPIC. Now, as we understand it, the index is created from this properties section on EPIC. And so when the index is automatically generated, it does not contain a date or a nominal for the undercover officer by reference to each specific report. Now, this is a significant departure from tranche 1, where, of course, we had hard indices that did contain dates. And it's also somewhat a departure from the indices that some of us, or some of the non-police stakeholder participants had in tranche 2, which again did contain dates. I mean, the reality is not having a document dated on an index or even on EPIC makes understanding the disclosure virtually impossible, particularly where those documents can't just be sorted chronologically on EPIC. And essentially on Opus, that's what we did. As well as having the index, we just clicked on the date icon, and everything was instantly in chronological order. So we asked the inquiry to focus on trying to resolve this issue, in particular by reference to the date, because it is considered that this will significantly assist with speeding up work on the Rule 9 statements now, but hopefully as well in the future. Another related issue is that the disclosure on EPIC often, not necessarily always, but often, from what I've heard, bears no relation to the order by which documents appear on the index. So I undertook earlier a spot check of Miss Steele's disclosure, as this is the only T3 disclosure that I can currently see. So this is not all Miss Steele's T3 disclosure, just a very small proportion of it. But what is immediately apparent is the order of documents on EPIC in the folder bears no relation to the ordering of the documents on the index. Essentially, the documents on EPIC are simply a mass of documents jumbled together. And as indicated by Ms. Steele a moment ago, the obvious solution, aside from a master index, is essentially a spreadsheet of the disclosure, which would be akin to a master index. At the very least, having the control number on it, the document description, the officer's nominal, and crucially, the date of the document, which can then obviously be sorted through the spreadsheet very easily on Excel technology. And then analysis can either be put into that Excel document, or that Excel document can simply be used to sort the material. So this work clearly needs to be done. So that's dating and clustering of documents with nominals, control references. Previously, this work was undertaken by the inquiry, as it's clearly the inquiry's job to do this work. It's critical that this work continues to be done by the inquiry before disclosure. Otherwise, the burden of doing this work is simply shifted onto the non-police state corps participants, and that this is clearly what's happened in Tranche 3 and what's contributed to some of the problems and delays that have arisen. This cuts into time for preparation of the statements, but as you've heard, and I've made the point many times, it just makes analysis virtually impossible, particularly where you can't print, but hopefully that's been fixed now. Now, in terms of deadlines, you'll know, sir, that there is that general request in my written submissions referencing the 30th of April or 12 weeks, whichever is later, from receipt of the Rule 9 request. Clearly, matters have moved on in today's hearing. I understand that there may be some non-police state corps participants who, notwithstanding any general extension, may in fact be in a position to submit their statements within their deadline. And obviously, if they can, they should, as that would clearly assist the inquiry. I think that all that I can ask at this stage is that you consider any extended deadline to be afforded to any other non-police state corps participants who may require it to the 2nd of May. But clearly I'm not in a position to make detailed representations on behalf of individual corps participants. So I'm really making this request as a general request, reflecting on the higher level points that I have raised. So I don't think I can really say anything more about that. Moving on to a separate discrete issue. So can I ask for urgent clarification from the inquiry on the date for submitting reporting restriction order applications? By way of background, a letter was received from the inquiry of the 6th of March 2025, suggesting the deadline was the 11th of April 2025, i.e. the same date as applies for privacy redaction applications. RRO applications are not required for preparation of the bundle, and actually they can't be sensibly submitted before statements have been finalised and before full instructions can be taken in light of said fully completed witness statement. There is the real risk that if RROs are sought too early in the process, then the inquiry will face similar difficulties that arose very recently in Tranche 2 around needing to finesse the wording in light of full reflection on all of the disclosure. So can I, because there isn't those bundle implications for the inquiry, can I ask you to make an order today, sir, that applications for RROs are to be made when witness statements are served or by a later date with prior agreement from the inquiry. I'm hoping that's not controversial because it's, as I say, there are no implications for the bundle, but clarity is required there. And then I was finally going to move on to the issue of communication. It's clearly been touched on already at length by lots of different individuals and call participants. You know that there was supposed to be a meeting today, but it was postponed. It's again just a plea to ensure that those regular meetings are recommenced. I know you've indicated that there will be. They did in tranche 2, albeit there were disagreements, head off and diffuse difficult matters and avoid miscommunication before there became a crisis. So I think that's, ultimately why those meetings are in the end important. Just finally, there's another issue that I'm asked to raise, a general issue, and this is just to flag to you, sir, that I am informed by lots of non-police state call participants that sadly the inquiry team is at this point now not responding to emails at all for quite significant periods of time, or not doing so promptly in the required time that the inquiry is set for itself. And I understand there's potentially quite a significant backlog. Obviously, a lot of issues have been resolved today, but I understand that that is still an ongoing issue. So I'm just asked to raise that today as we have an opportunity to raise things with you. So those are my submissions, unless I can assist you further. Thank you.
Now, I'm grateful to you for those submissions. I am not going to respond to your 2 specific requests today. That needs input from the inquiry team and those who are assisting them with technical issues, which I cannot get instantly, and I doubt would be useful if I were to attempt to do so. But what you've said has been noted and will be acted upon.
Understood. Thank you, sir.
I'm afraid I must end with one point. We're now only 5 minutes after we've got to conclude completely. And that is this. The COPS statement, which requested today's hearing, purported to be signed on behalf of 92 individuals. I have reason to think that not all of the individuals upon whose behalf the letter was purported to have been sent could conceivably have signed it. It included, for example, 7 people who have already provided evidence to the inquiry, and I find it difficult to believe that they would have wished to make submissions about a stage of the inquiry's hearings in which they are not being requested to participate. So for those reasons, in future, no letter of this kind will be considered by the inquiry unless it is produced by the recognised legal representatives.
So could I just jump in there just to clarify? Everybody that signed that letter did indeed say that they supported that letter. It's true that some people had already or weren't had already submitted statements or whatever, as you said, but they wanted to sign in solidarity. As far as I understand, every single name is verifiable as someone who came forward to sign that statement voluntarily.
Well, you know that you will know better the authors of the document than I do. All I'm saying is that I have reason to think, my thought may not be justified, but I have reason to think that not everybody whose name was given as a signatory, not necessarily a supporter, but as a signatory of the letter, did in fact sign it or indicate their assent to it in the form in which it was sent. And for the avoidance of doubt and difficulty in the future, all I'm saying is that any such collective letter must come through the recognised legal representatives. letters from individuals will, of course, be treated as from the individuals who've signed them or attested them in a manner that makes it clear that it comes from them. All I'm pointing out is that corporate statements of that kind will not, I anticipate, in the future be responded to. That concludes today's proceedings. Thank you all. We have made progress. The progress, I hope, satisfies some of the difficulties in which people have found themselves. It is, as I indicated at the start, not a discussion exercise, but a decision exercise. Decisions have been made. They will not be departed from, save in circumstances that could not now be anticipated and where exceptional circumstances in addition arise. This is the final say, not a step towards the final say. Thank you. That concludes today's hearing. Thank you all.